Good afternoon. I'm Dan DeRose with 19 News, coming to you from our digital desk. We're going to be taking you live into Cuyahoga County Court here. That man is about to be sentenced for a double murder. This is Phoenix Brown, and this is a situation that happened in Slavic Village back in January of this year. He was a part of 3 young men that were in a stolen Kia. Yes, they were a part of the Kia Boys, when all of a sudden that Kia crashes. It turns out 2 of the individuals inside that car were shot and killed. They were dead on the scene. That is Kaylin White, 17 years old, and Julius Barron. Now, police pull up to the crash and they see Brown running from the scene. They chase him down, and when they grab him, apparently he was covered in blood. He was then charged with their murders. He went to trial in mid-October. The jury found him guilty of aggravated murder, felony assault, receiving stolen property, and having weapons under disability. That means he was already a felon and should not have been in possession of a gun. The courtroom is packed, to say the least. They have had to turn away some people in that courtroom, and there is a heavy presence, as you can see, of bailiffs in the courtroom. We get the all rise. There is going to be a lot of tension in this courtroom, and you're going to hear victim impact statements. Family members who are very emotional give their testimony on what this has done. The death of Kaylin White and Julius Barron has done to their family. So let's take you live into the courtroom.
Instructions from the court. There's not to be any recording in the back of the room. No behavior that would disrupt these proceedings. Both the lawyers for the defendant as well as the lawyers for the state have put a lot of work and effort into these proceedings, and there should be no interruptions of that, either now or during the time when they're speaking, or the defendant is, or at the time that the court renders a sentence on this matter. All right, thank you. Court will state for the record that there are 2 cases in front of it for sentencing. This is the State of Ohio versus Phoenix Brown. Those case numbers are 698-632 and 700-674. At the time of the trial, the court allowed the 2 matters to be tried to the jury together, but we did renumber the counts so the jury would have a clear, concise, sequential order in their determinations. Those counts being count number 1, aggravated murder, count 2, aggravated murder to begin with, in case 698-632, to which there were findings of guilty on all counts on that case number, 698-632, ending in count number 11, receiving stolen property. Then there's case 700-674, in which we began. The first count is count 12 in sequential order for the jury. That would be the aggravated robbery, count 13, grand theft when the property is a firearm, count 14, possession of fentanyl, and count 15, which was decided by the court, having a weapon while under disability. The jury came back guilty on all their counts. The court as well came back guilty on the having a weapon while under disability beyond a reasonable doubt. The court has provided both counsel with the most recent pre-sentence investigation report after the defendant had been guilty, that is convicted by way of a guilty plea on an earlier case number, 684141. Mr. Schlackett, have you had an opportunity to review that?
Thanks to your wonderful staff, Your Honor, we've had an opportunity to review that information. I don't believe Ms. Tipping or I have any additions or deletions, and believe the information contained in that report to be factually accurate.
Thank you, Mr. Schlackett. With Mr. Schlackett is attorney Mary Jo Tipping, and between them is the defendant, Phoenix Brown, brought up from the county jail for his sentencing. And the state of Ohio was represented by assistant prosecuting attorneys Kristen Carcutt and Jordan Mason, who are both present. Ms. Carcutt and Ms. Mason, have you had an opportunity to review the pre-sentence investigation report?
Yes, we have.
I had reviewed this, and as I reviewed it, I noticed that there was a case that was entitled a pending case, and if the parties have any further information about that, that's DL 23113591 in juvenile court. It's for an incident date that occurred on October 30th of 2023. It's on page 5 at the very top of that pre-sentence investigation report. Ms. Mason, do you have any information, or Ms. Carcutt, as to that matter?
Yes, Your Honor. So the case number in which the defendant pled guilty here in the Court of Common Pleas was 23-684-141. I've addressed some of this in my sentencing memorandum, Your Honor, but the defendant was sentenced to a 9-month term of incarceration in that matter. Once the court granted the defendant credit for time served, that almost essentially obliterated that 9-month sentence. He went to a correctional, a pre-correctional facility, if you will, for 2 days prior to being released in January of 2024, 2 days after he was sentenced. He then went to juvenile court and dealt with that matter in case number 23-113-591. And he ultimately pled in that case. And those charges involved having a weapon under disability, improper handling of a firearm. And at the time that he pled in that case, he was already being supervised by the Adult Parole Authority for the attempted felonious assault case in 684-141 that he pled to here in the Court of Common Pleas, Your Honor.
So that matter was retained over at juvenile court, even though there had been an adult conviction?
It was not. Correct.
All right, thank you. Okay. All right, does the state have any desire to make any changes to the pre-sentence investigation report?
Other than just providing the court with that follow-up information and that case has since been resolved.
All right, thank you. All right, so we'll hear from the state of Ohio to begin with Ms. Carcutt.
Thank you, Your Honor. I did file a sentencing memorandum. I think that's been received by the court. I'll note, let me start with respect to merger, Your Honor. It's the state's position that counts 1, 3, 5, 7, and 9. Those are the aggravated murder, and felonious assault counts as they relate to victim Kaylin White. They all merge for the purposes of sentencing, and the state elects that this court proceed to sentencing on count 1. It's the state's position that it counts 2, 4, 6, 8, and 10 aggravated murders, and felonious assaults as they pertain to victim Julius Barron, all merge for the purposes of sentencing, and we ask that the court proceed to sentence on count 2. Counts 11, 12, 13, 14, and 15 are not subject to merger. I outlined where we are in terms of the firearm specifications with respect to 29-14 B1G, which states where a defendant pleads guilty or is found guilty of one or more felonies, one of those being aggravated murder, aggravated robbery, or felonious assault, this court shall impose upon the offender the 2 most serious firearm specifications. So because we're dealing with 2 incidents on different dates, it's the state's position that there are a minimum of 12 years of firearm specifications that must be run consecutive to the sentences that this court imposes on the underlying offenses. So 2 for the aggravated murder case, if you will, 2 3-year firearm specifications there, 1 for the aggravated murder of Kaylin and the other for Julius. And then with respect to the offenses that have occurred on a different date, that would be the aggravated robbery of Shane Dickens as well as the theft of the firearm for an aggregate total of 12 years of firearm specifications. And it's certainly within this court's purview to sentence according to that statute, to sentence the defendant to more than those firearm specifications than just the 12 years. However, it's the state's position that with respect to the discretion this court has in the imposition of the sentences on each of these aggravated murders, that probably won't be necessary for the court. I know that there are family members of both Caitlin and Julius here in the court today. They've been present and attentive for the duration of this trial, and they will wish to address this court. I would like to point out that at the time that the defendant committed the aggravated robbery of Shane as well as the grand theft of the firearm, he was still under the supervision of the Adult Parole Authority, but that terminated on January 11th of 2025. And then the aggravated murders of Caitlin and Julius happened 4 days later on January 14th. This court had the opportunity to sit through this trial. You were a finder of facts. You heard all of the evidence in the case, and you saw the state's exhibits. And unlike a lot of the other shootings and murders that we see in our community, this isn't something that popped off at a gas station or had this idea that you have a bunch of teenagers that are just disrespecting one another. These are two kids that were in a car with someone that they knew, and that someone that they presumably trusted. And you know, this isn't one group shooting at another group. These are two calculated executions of a 16-year-old and a 17-year-old. They both received 2 gunshots to the head at very close range from within this vehicle at the hands of the defendant. And that's what this jury returned the verdict of. That this was cold and calculated and planned. And this isn't a spur-of-the-moment type of situation that popped off as a result of just kids running around with guns. This was an execution, and it wasn't one, it was 2. As I noted, you have a lot of discretion here with 2 separate aggravated murders. Your Honor, you can run these concurrent or consecutive to one another. In life without parole is the maximum penalty that the defendant would face on just 1 aggravated murder, and we're here on 2. Not to mention that there are 2 other victims named in the counts for which the defendant was found guilty, and that is the owner of the vehicle, the Kia, for which he was in receipt of stolen property, and also for Shane Dickens for robbing him of that firearm, and really ultimately his grandfather too, who that firearm belonged to. So to ask the court to keep that in mind when it fashions a sentence for this defendant. Some of the seriousness factors for this court to consider in terms of the nature of these offenses. Is this the most serious form of the offense? It is, times 2, because these were executions of these boys. And the fact that the defendant was under supervision, at least at the beginning of this course of conduct that led us to these 2 aggravated murders, he was under the supervision of the Adult Parole Authority, even though that had terminated before he ultimately carried out these aggravated murders.
One moment. Everyone will take the opportunity to silence their phones, please. Thank you. Yes, Ms. Carpenter.
Certainly when this court considers factors that are less serious, I don't really think that you can find any, but with respect to any mitigation, certainly the state of Ohio recognizes the youth of this offender, but I point out, as I did in my memorandum, Your Honor, that the defendant preyed on victims younger than he. They're 16-year-old boys and a 17-year-old boy. So when you're looking at that, I think those things kind of wash each other out, if you will. It's what makes this case more serious. And while I get that he's young, I think that's something for the court to consider. And when you look back at the defendant's only other felony conviction as an adult in this court, where he pled to attempted felonious assault and shooting over a roadway and improper handling of a firearm in a motor vehicle, those things sound remarkably familiar, yet less serious than for what we are here for today. But those victims there were also people that this defendant knew. I don't know what's, in terms of Phoenix Brown, if it's scarier to be his friend or to be his enemy. And I think that this court's sentence should reflect that. So with that being said, Your Honor, I'd like you to hear from the victims' families.
Yes, who would you like to call first? Hello.
Hello.
Sir, what is your full name, your first name and your last name?
First name Calvin, last name White.
All right, sir. And you are Kaylin's
Father.
All right, sir.
Hello, Your Honor. My name is Calvin White. I'm Kylan White's father today. I'm here on behalf of my son and his best friend, Julius Barron, whose lives were taken away too soon. They were teenagers, never had a chance to do anything. As a parent for the last 8 or 9 months, I've been having a hard time accepting this. Phoenix Brown, you changed everybody's life. Your family, my family, and Julia's family. I'm not here to bash you. My son is gone. I had to have a funeral for my son before he turned 18 years old. To see my child in the casket is something I'll never forget. We do not know you. Not me, not my kids, not his mom. No one, so you're not his friend. I know his friends. Today I'm here seeking justice for my son and his best friend. You killed them with no remorse, and today, Your Honor, I'm asking that you sentence him with no remorse. He's not fit for society. That's all I have, Your Honor.
Mr. Barron, did you know him as well?
Julius, yes.
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 And they were best friends, you said?
Yes.
How long have they been friends?
For at least 3-4 years.
Thank you, sir.
You're welcome.
Good afternoon.
Good afternoon, Your Honor.
Could you tell us your full name?
My name is Stacy Fussell.
How do you spell your last name?
Fussell.
All right. Yes, what would you like to say?
I'm the mother of Kylan White. On January 14, 2025, my son was taken from me in the most tragic, senseless way imaginable. That night, my son Kylan was with his best friend, Julius Barron, were both killed by the same person, Phoenix Brown. 2 young men, 2 best friends, their lives ended in one violent moment. The devastation from that night didn't just take our lives, it shattered 2 families, mine and Julia's, and it left a hole in our hearts that will never heal. Kylan was my child, full of life, full of laughter, and full of potential. He wasn't perfect, he made mistakes, and he was still finding his way in the world. But he was trying, he had goals, he wanted to do better, and he was learning from what mattered. He was learning what mattered most. He was more than just his past. He was my son and and I loved him with every piece of my heart. He loved deeply, especially his brother and sisters. He was the one who made them laugh, who filled our home with his big personality and energy. Now that he's gone, I see the pain in their eyes every day. They struggle to understand why someone would take their brother away. The laughter in our home is replaced with silence and broken hearts. And the pain is matched by the pain, and our pain is matched by the pain of Julius Barron's family, because we lost both of our boys that night. Julius wasn't just Kylan's best friend, he was like another son to me, and that bond was shattered. Now both of our families are broken. 2 mothers without their sons, 2 families robbed of futures that were just beginning. Phoenix Brown, you did this. You didn't just take 2 lives, you destroyed countless others. You took away birthdays, graduations, weddings, moments that should have been filled with joy. Left a trail of pain that reaches deep through the families and friends of Kylan and Julius. There is no day that goes by that I don't replay the night in my mind. No day that I don't wish I could hear my son's voice again or hug him one more time. The pain is constant. In my heart, in my home, in the faces of my children who will never stop missing their brother. Your Honor, I want you to understand that the loss is more than just two names in a case file. Kyla and Julius were sons, brothers, best friends, and also human beings who matter deeply. Their lives were stolen, and the impact will be felt forever. We will carry this pain for the rest of our lives. All we ask is that justice reflects the gravity of what was taken from us, not just from one family, but two. Thank you for allowing me to speak today, Your Honor. Julius and Kyla's lives meant everything to us, and they will never be forgotten. Forever 17, forever 16. Thank you.
Thank you. Good afternoon.
How you doing, Your Honor? My name is Frida Tucker.
Yes, Ms. Tucker.
F-R-E-D-A-T-U-C-K-E-R. I'm Julia's grandmother. And what I want to say is that it's like starting all over again. Praise be to God. Death is never easy. It's never easy. This thing have taken a toll on my daughter. Very hard. And it's taken a very hard toll on me. I'm sick. I'm on dialysis. And this have taken a toll on me. But I do understand. I do understand. I'm just hoping and praying that something good come out of this situation. Nobody wins. Nobody wins in this situation. I feel for every family here today. And I just thank God for the ancestors for being with me, and two families back there in the back all week long. We've been coming down here, and we're just grateful for Sabrina, who has been a great advocate in helping us get through this process. And we're thankful for our lawyers and all those that have been involved in this case. We're grateful. So I'm just looking for justice, and I don't know what justice is going to look like, but I'm hoping that justice will be served, and I hope that Mr. Brown will somehow find himself through this process. I hope that he find himself through this process. We are all hurting here. We're all hurting. And I just want justice to be served for my children, my daughter, who has really, truly been suffering and been hurting. And we're just grateful and we're just thankful. Thank you.
Thank you, Ms. Tucker. Anyone else, Ms. Tucker?
That's all, Your Honor. Thank you.
All right. court has reviewed the state sentencing memorandum. Imploring the court to fashion a sentence that will adequately serve all of these overriding principles stated in the revised code. So, Mr. Schlaget, who would like to speak at the defense?
We're arranging that now, Your Honor.
Yes.
Please.
Your Honor, I think two individuals, one of his aunts and his grandfather.
All right. Mr. Schlaget, would you like that to occur now?
How about if we go first, Your Honor, and then we'll have the family speak?
That's fine.
May it please the court, Your Honor, just some mitigatory remarks regarding Mr. Brown.
Judge, you had the advantage, at least in fashioning a sentence, that you got to hear the entire case. That's different a lot of times than when you just take a plea and you just have an antiseptic pre-sentence investigation report, which really doesn't reflect the nuance of the case, the underlying events. So in this case, at least you have the advantage of fully knowing what happened. But here's the problem. Nobody knows what happened inside that car. As you know, Judge, the evidence against Mr. Brown was based solely upon DNA evidence that he ran away from the scene with the gun in his hand. The kids, young people, I don't mean to be pejorative in my speaking, the young men who were in the car, you heard from them both, but you didn't hear them say anything. One of them ran away, so we didn't get to hear from him. We heard a little bit from statements, but we didn't hear from him. And then, of course, we had Christian, I won't use his full name, you know who I'm speaking of. He came in, and despite the benefit he was offered, he rejected that and asserted his Fifth Amendment privilege. I only bring this up, Your Honor, just to point out, we, as we stand here today, truly do not know what happened in that car. Ms. Carcutt's going to tell you it was a cold-blooded execution. The evidence was that this young man ran away simply with the gun. He was 18 at the time. I'm not saying that's okay. If he was a few months younger, he would have been a bind-over situation. That doesn't make it right. It's a tragedy. Two young men lost their lives, and Phoenix is going to lose the rest of his, basically, whatever the sentence is. It's going to be very lengthy, and he knows it. We agree with the merger analysis by the government, Your Honor. Where we disagree a little bit is under the interpretation of the revised code section regarding 2929.14B1G, which is, of course, the statute that says if there's guns involved and it's a murder or an aggravated robbery or, you know, that list of cases, that there has to be at least 2 gun specifications and the court could impose more. But if, from my perspective, and I think Mary Jo agrees with me, it's 6 years on the incident involving each of these 2 young men, so that's a 6-year gun spec, and then there's a 3-year for the robbery of Shane Dickens. And of course, Your Honor, again, if it had happened a few months before his 18th birthday, in juvenile court, you can't even get a gun spec unless you're the primary perpetrator. And as you heard from the evidence, the theory was that it was on complicity. Of course, in adult court, I'll concede that complicity could cause the imposition of a firearm specification. So we're asking, Your Honor, that you impose a 9-year firearm specification for the different events rather than the 12. The merger
for the aggravated murder, and the aggravated robbery. But
yes.
You're saying not for what the state is suggesting, that the 3-year firearm spec for the grand theft of a firearm would not apply? Is that what you're saying?
I don't think that that has to apply because grand theft is not one of the listed subsections in 2929.14B1G. That talks about aggravated murder, murder, attempted aggravated murder, aggravated robbery, felonious assault, or rape. Not about a theft. So that's...
At that statute itself that you're addressing,
Yes.
the court will take the opportunity to read that here into the record. Revised Code 29.14B1G, if an offender is convicted or pleads guilty to 2 or more felonies, if 1 or more of those felonies are aggravated murder, attempted aggravated murder, aggravated robbery, felonious assault, or rape, and if the offender is convicted of or pleads guilty to a specification of the type described under the Division B1A of this section in connection with 2 or more felonies, the sentencing court shall impose on the offender the prison term specified under B1A of this section for each of the 2 most serious specifications of which the offender is convicted or to which the offender pleads guilty, and in its discretion also may impose upon the offender the prison term specified under that division for any or all remaining specifications. So you have 2 case numbers here. You have the aggravated murder, which would be the 2 highest on that case number, the 2 most serious. And then you have the aggravated robbery, and then there's another count as well, 2 other counts, right, for the theft of the property and for the fentanyl-related compound?
That's a separate drug possession you're talking about?
Yes, but that is for an event that occurred on January 14th. So if I understand the state's position correctly, these are 2 separate dates, and so the 2 most serious firearm specifications apply.
With respect to the fentanyl possession and the drug and the firearm specification, Your Honor, the court certainly has to impose at least 2 of the most serious offenses, which is 6 years, and then it's discretionary to do another 3 years. That was a continuing course of conduct, as you well know, Your Honor. In terms of time passage, it was seconds or minutes. It's from when Phoenix ran away from the car with the gun in his hand, and then he had the fentanyl in his possession. So we still stand by, of course, you have discretion, the court can do it at once, but I'm submitting most respectfully that we're asking you to exercise your discretion with the imposition of a 9-year firearm specification, which of course has to be prior to and consecutive with the underlying sentence, which is obviously going to be, it's aggravated murder 2 times. Those don't merge, so.
And as to those underlying sentences, you said that you and co-counsel do not disagree as to the counts that the state has advised the court are allied offenses and that would merge, so the other counts, in your opinion, also would not merge them?
Yes, Your Honor. All the crimes of violence against Mr. White merge with respect to Mr. White. The crimes of violence with respect to Mr. Barron merge for Mr. Barron, but the crimes against Mr. Barron and the crimes with Mr. White do not merge because they're separate victims. And we understand that.
The grand theft of the property and the aggravated robbery do not merge.
I think that the theft is part and parcel of the robbery. I mean, he was robbed, if you believe his testimony, of his gun, his hoodie, his cell phone, and his Instagram money. Remember, he called it, I think, play money. That's what the aggravated robbery was, Your Honor. It was of the gun. So I think that the grand theft of the gun does merge with the underlying offense of the robbery. It's the same act. It's one's mens rea. It's one culpable mental state. It's one incident with one victim at one time.
I just wanted to understand your arguments.
Yes, I'm sorry.
And then you were going on further. You were, after we were done with the merger analysis, you were going to speak about the other counts on the indictment as well, or no?
The other counts do not. I mean, certainly the drug possession doesn't merge. The weapon disability that this honorable court convicted him of, that's not going to merge. So, you know, that gives you even more, the court even more leeway than it needs already in terms of discretionary sentencing. Your Honor, I'm not going to be bold enough to come up and say to you, here's what we think is an appropriate sentence. We're confident that you can put aside all of the emotional involvement in this case, because obviously 2 young men lost their lives and it's extremely emotional. But I know that you can dispassionately consider all of the factors of 29, 29, 11, 12, 13, and 14 and craft a sentence which will not demean the seriousness of the offense, will adequately punish this offender, will ensure that government resources are not used unnecessarily, and where, as the victim's family said, where justice will be meted out correctly. We're confident that you'll, consider all of those factors and not just the inflammatory nature of 2 young children losing their lives. Your Honor, there's very little that we can say. I know that the family is certainly interested in closure and having Mr. Brown stand up and say, I'm so sorry for what happened. He has been, and he'd like to talk, Your Honor. Ms. Tipping and I have given him counsel, asked him not to allocute on his own behalf because he certainly intends to thoroughly process his appeal and his appellate rights. And we don't want anything that he says in open court to jeopardize his potential rights in his appeal, Your Honor. We most respectfully hope, and I know you won't hold that against him, that he does not allocute, and you won't interpret that as a failure to accept responsibility. It's merely him following the advice of counsel. Saying that, Your Honor, if...
And you have then apprised him of all the factors and of the sentencing guidelines that you've already mentioned, that he has a right to speak to the court, and the court could consider, if he spoke and showed genuine remorse, that factor is having some weight. Is that correct?
Yes, Your Honor, but at the same time, I hope the court can appreciate why we have given him the advice we've given him.
I do. I just wanted to make sure the record was clear that he's been apprised of his right to do so and what effect that could have under the revised code sections that you're talking about.
He has been, Your Honor, and frankly, without getting into privileged communications, it's been a struggle for us to convince him not to address this court and other people that are in this open room. So with that, Your Honor, unless Ms. Tipping would like to make some comments, other than that, we'd like you to consider some comments from his family.
Thank you. Ms. Tipping, would you like to make any comments yourself?
Your Honor, I don't have anything to add to what Mr. Schleich has placed on the record.
And then, Mr. Schleich, you said somebody wished to speak on his behalf.
With your permission, Judge, just 2 people, they won't be lengthy.
They can say whatever they wish to say.
Thank you, Judge.
Hello, sir.
Good morning.
And what is your full name?
Your Honor, my name is Michael Brown. I'm the grandfather of Phoenix Brown. This is a tragic, tragic thing that has happened. We're just here in support of him. We want the family to know that this situation, we are sorry that this happened. And we try to understand some things of what these young people out here doing. We also are a victim of, my grandson was killed also by some people that he thought he befriended. So I understand how they feel. These young kids out here today, who knows what motivates them to do the things they do and act the way they act. It's not that.
I'm sorry about your loss. When did that happen?
This was about 5 years ago.
Would this be Mr. Brown's
cousin?
Cousin.
Yes.
All right.
One of my other grandsons.
Mm-hmm.
But like I said, we don't know what motivates these kids out here nowadays. You know, try to be a good parent, but when they get together, they turn into different people. You know, they do things that we consider not making sense to us, and they get lost in what they're doing. You know, a lot of things have changed in society now, so, you know, we try to do the best we can. But things happen, and this is something that is affecting their family strongly, our family strongly. They won't see theirs. We have a chance to see him, yes. But he's finna do a lot of time, we understand that. Like I said, we're here in support of him, and hopefully there'll be a brighter day. And that's all we can do is try to be there, try to get them on a better path, try to say things that will encourage them to do something more positive with their life. But, you know, when they get together, they, like I said, they turn into different people. And I just want to say that, you know, we're sorry that this came about, you know, and I know the family, we have remorse also, you know, because like I said, I lost a grandson. So I know how that feels. I'm somewhat of a loss for words to try and explain this, because this is so confusing. It really is. It's so confusing. And we all, you know, we all have to take into consideration that we did the best we could with raising our children and trying to get them to go on a better path. And sometimes it just, a curve comes and they take it and it takes them somewhere that, you know, they really don't need to be. But taking all that into consideration, Your Honor, you know, I know that Phoenix was trying to go to school. He was trying to get his life together as far as some things, you know, and he was hanging out with the wrong crowd. And some things happened that should not have happened. But he was trying to do better for himself. He just got caught up, wrong place, wrong time. So with that said, Your Honor, I thank you for the opportunity to speak. And as I said, I am sorry that these things took place to the family. I really am. I apologize that this thing happened. So we just got to move forward with what's going on right now. I thank you.
Thank you, Mr. Brown. Ms. Tipping, then? Someone else?
Thank you.
Hello.
Hello.
And what is your full name?
My name is Shalonda Brown.
How do you spell your first name?
S-H-A-L-A-N-D-A.
All right. And what would you like to say?
I would like to say that
How are you related to
this is my nephew. Phoenix is my nephew.
All right.
I'm his aunt. I helped raise Phoenix. I know him very well. I'm a mother of 4 boys. I have a stepson. And like my father said, we did lose my nephew. That happened 2 years ago. So Phoenix is probably dealing with PTSD behind that. I do want to ask for grace and mercy from you, Your Honor. And I do want to apologize to the family of Kaylin and Julius. I know this is not easy. We just went through the same thing 2 years ago, and it's heartbreaking. It really is. Phoenix is not a predator. He does not need to prey on young people. The people that died was 16 and 17, and Phoenix was 18. He was only a year older than the boys. He does not need to prey on anybody. We did not raise him like that. He was raised in the church. He knows God. He knows the Lord. And he knows that that is not right. That's why the young man got up there and said that he tried to stop the robbery, because he was raised in the church. He knows right from wrong. Unfortunately, this did happen, and I hate that it happened. I really do. I pray that we can come together, all these people in here. I pray that we can come together as a community and come up with some type of resolution of what to do with these young people, because this is not going to stop. They are bored and they have nothing to do. And we need to come up with some type of resolution for them. Unfortunately, this did happen. But there were other people in that vehicle, and we don't know what happened in that car. I pray for grace and mercy upon you, nephew. Unfortunately, this did happen. And I hope that we can come up with some type of resolution as to save these young people, because at the end of the day, they are the people that's going to take care of us in the end. So I just hope that we can come up with some type of program to help them out. I really am asking for mercy upon his sentence. I stick by my nephew. I support you, nephew. You said you didn't do this, and I believe you. Thank you for your time, Your Honor.
All right.
Thank you, Your Honor.
Thank you, Mr. Schleicher. Could you bring this to your client, please? This is the Reagan-Tokes form. The court will go through with him and you on the record as it's obliged to do so. Specifically, this would apply to any felonies of the first or second degree which he was convicted of, those being here the aggravated robbery and the possession of a fentanyl-related compound. The aggravated robbery being a felony of the first degree and the possession of fentanyl-related compound being a felony of the second degree. So this is the statutory notification that needs to be read to the defendant to advise him of those. Mr. Brown, you have that in front of you. I've got to make sure that you can read that as we go along here. You're being notified that it is rebuttably presumed that you will be released from the service of the sentence on the expiration of the minimum prison term imposed as part of the sentence or on the offender's presumptive earned early release date as defined at section 2967.271 of the revised code, whichever is earlier. You're also being notified, and I'll point you to paragraph 2 there, that the Department of Rehabilitation and Correction may rebut the presumption described in Division B2C1 of this section if at a hearing held under section 2967.271 of the revised code, the department makes specified determinations regarding your conduct while confined, your rehabilitation, your threat to society, your restrictive housing, if any, while confined, and your security classification. Paragraph 3, that if as described Division B2C2 of this section, the department at the hearing makes the specified determinations and rebuts the presumption, the department may maintain the offender's incarceration after the expiration of that minimum term or after the presumptive earned early release date for the length of time the department determines to be reasonable, subject to the limitations specified in section 2967.271 of the revised code. Paragraph 4, that the department may make specified determinations and maintain the offender's incarceration under the provisions described in Division B2C 1 and 2 of this section more than one time, subject to the limitations specified in section 2967.271 of the revised code. And paragraph 5, that if the offender has not been released prior to the expiration of the offender's maximum prison term imposed as part of the sentence, the offender must be released upon the expiration of that term. Now, the following paragraph is also in front of you. Additionally, the court has notified the defendant that pursuant to revised code 2929.19 B2C, the offender is eligible for earned reduction of 5 to 15% of the minimum prison term imposed for exceptional conduct while incarcerated or adjustment to incarceration, period. Earned reduction of minimum prison term, ERMPT, does not apply to an offender serving a prison term on a life sentence or on a non-life indefinite prison term for a sexually oriented offense. This does not apply to mandatory aggravated murder sentences, and it will not apply to the firearm specifications. But it would apply to those two underlying crimes that I've just mentioned to you here. So I read that to you in my obligation to the court. All right, sir. Now, in reviewing all of the matters here, I will note that I have reviewed the pre-sentence investigation report, the state's sentencing memorandum. I've heard from counsel and the defendant, his family, that is. I've heard from the victims' families as well. I've reviewed 2929.11 for the principles and purposes of sentencing, 2929.12 for the seriousness and recidivism factors, and 2929.13 and other revised code sections for felony sentencing. The court has formulated the following decision based upon the overriding principles and purposes of felony sentencing, which are to protect the public from future crime by the defendant or others, and to punish the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing for restitution, and the court has considered the relevant sentencing guidelines provided in revised codes 2929.11, 2929.12, and 2929.13, as well as 2929.19. Now, I saw you following along, sir, with what I was discussing, and Mr. Schlackett, have you advised him already of his Reagan-Tokes advisement on those counts that are applicable?
Yes, Your Honor, we made him aware of the Reagan-Tokes could be applied to the one underlying offense that's not the murders.
Yes. That being the aggravated robbery, and the fentanyl was also a felony of the second degree. Yes?
Yes.
All right. Well, Mr. Brown, I'll note here there were 2 shots to the head of each of your victims. Only 1 shot to the head in such close quarters at point-blank range would have been all that was necessary to take life. But your decision to shoot and kill each of them was so certain that you shot each of them 2 times in their heads. Julius Barron was only 16 years of age. 2 shots to the back of his head. And Kalen White was shot to his forehead and also to the back of his head. Both were executions. It leaves no doubt of your calculated decision to definitively destroy their lives. 1 shot would have been enough, but your continued decision to shoot a second time on each victim shows your actions were designed and calculated. They were decisive, and they were certain to destroy life twice. There was no evidence that they had or would use a firearm or they were of any threat to you. You executed 2 people in cold, calculated fashion. Then you ran with your treasured firearm and your fentanyl. You were pursued by the police. You seemingly got away. But the police, and they did an incredible job locating you, using real-time cameras and analysts and a coordinated effort to set up a perimeter around you. They showed professionalism and a lot of restraint. In arresting you. It was a very, very dangerous situation, not only for them, but for you too. And all of it was caused by you. Notable to the court was the fact that you wanted to keep that gun and those drugs. At any point, you could have tossed them aside and thrown them away. You could have been disgusted at your own actions for taking life from those 2 young people. But you coveted those items so badly that you kept them. Throwing the firearm only at the very last possible moment before your capture, caught on tape. Those Instagram videos of you displaying your gun throughout that evening and pointing it right into the camera. Was this the last thing that Kalen saw? They're chilling. The evidence that taking their lives simply didn't bother you, sir. They were not just calculated, your decisions, but they were callous. You committed an aggravated robbery of another friendly acquaintance, Shane Dickens, just 10 or 11 days earlier. And you did so while you were on post-release control. The evidence that's in front of the court is that there is no restraint in your behavior. In fact, your behavior shows a pattern of increased violence. pre-sentence investigation report is somewhat telling, actually very telling. In DL 2010747 in juvenile court, you had an offense date of August 10th of 2020, and on March 8th of 2021, you were adjudicated delinquent for this receiving stolen property. You were sentenced to 1-year probation. You were to continue with Peacemakers Alliance. You were to write a letter of apology to the victim and present the probation department with that letter to forward to the victim. You were to pay restitution. You were found to be a probation violator in that matter on May 9th of 2022. You were continued on probation for 6 months. You were to attend school regularly, pay the restitution, 1/2 of it. Your probation was extended on October 5th, April 5th, and July 11th, 2022, then 2023 and 2023. And it'll be clear why here, further on in your criminal behavior here. Then you had case DL 2210903. Offense date for that was July 21st of 2022. You were adjudicated delinquent and you're sentenced to 180 days in the detention center. You're given credit for 180 days, and you were released. Then came DL 22107546, that felonious assault, discharge of a firearm, improper handling firearms of a motor vehicle, criminal damaging. That case was bound over to the adult division. And it became case 678441, which was dismissed, but then re-indicted in case 684141. In the meantime, during that period of time, you had that assault, DL 22112538, and the court on April 3rd of 2023 adjudicated you delinquent, and it refers back to that earlier case number where it extended your probation on the earlier case of receiving stolen property. Now on that adult case that came over, you pled guilty to attempted felonious assault, discharging a firearm on or near prohibited premises, and improperly handling firearms in a motor vehicle. At that time, you were given a 9-month sentence. And what happened there is that the court gave you credit for time served for 265 days. So essentially, there was a revolving door. You got out of prison and you got out. That was July 23rd of 22. Attempted felonious assault was the incident date and the discharge of a firearm. Then February 3rd of 2023, bound over on that matter to that case number 684141. You had a GPS violation on October 30th of 2023. And if I go over to your probation department notes on that date, that matter there, although you had been warned before, you went across a zone into an exclusion zone, and the sheriffs had to go out and arrest you for that violation. When they arrested you on that date, October 30th of 2023, the sheriff's department officers, they were watching the car, and they saw an adult named Markle Morris open the car door. And it's at that point in time that they saw a gun in apparent view. There were juveniles, Ricky Leroy Parker and you, Phoenix Brown. Seated in plain view on the floorboard right between your feet was a dark blue AR platform-type pistol firearm. There were 3 firearms pulled out of that vehicle on that occasion. You were arrested for the probation violation, and they thought new charges may possibly come. And that's why I asked about this other case, that pending case in the pre-sentence investigation report, DL 23113591. There was another case, having weapons while under disability for that activity, October 30th of 2023, which is right there on the pre-sentence investigation as one of your offense dates. Having weapon while under disability and proper handling firearm. And for that pre-sentence investigation report, which was July 23rd of 2022, even before that date, the adult case, 684141, what happened there? You were at outside of a problem house in the neighborhood connected with several grand thefts of motor vehicles on Cloverside Avenue. The victims left in a black Honda Civic. I'm sorry, they left, and they saw a black Honda Civic that was, they believed to be stolen, drove up to them and fired 4 or 5 rounds at them and took off. One of those bullets striking the car on the back right side of the vehicle. You were on probation. You had an ankle monitor. And that's what you pled guilty to there. Attempted felonious assault, discharge of a firearm on or near prohibited premises, improper handling of firearms in a motor vehicle. And then comes your current case here, again, where you're inside of a motor vehicle with a firearm. But this time, shooting at 2 people point blankly inside your own vehicle that you were in. And you were the oldest person there in the vehicle. The gun comes back to you directly with your DNA on it, none of the others in the car's DNA, and those pellets from both of them matching up to you. So the criminal history here is quite evident, and the probation department even found you at that time to be a high risk level. But you went in and you came out, and according to the sentence here, you had 1 year of post-release control. You were sentenced there in that matter, and then you were given 1 year of post-release control. When you got out, that 15-year-old, Mr. Dickens. And then only a few days later, these 2 aggravated murders and the other crimes. So the court will take into account the entire statute as well as any mitigation that's been provided here and your criminal history in fashioning the following sentence. As to count number 1, aggravated murder, 2903.01A. We'll begin with a 3-year firearm specification, which must be served prior to and consecutive to your sentence. Your sentence will be a 30-year sentence on that. That is life in prison without the parole eligibility until after serving 30 full years of imprisonment, in addition to the 3 years. For the firearm specification on count 2, then, aggravated murder of Julius. For that, it'll be life imprisonment with parole eligibility after serving 30 years of imprisonment. Again, there'll be a 3-year firearm specification that must be served prior to and consecutive to that. As to count number 11, receiving stolen property, felony of the 4th degree, he'll serve a sentence of 18 months. Concurrently, the adult parole authority has the ability to supervise you for a period of up to 2 years at the discretion of the parole board on that count. Moving on to 700674, for the aggravated robbery, on the separate date there of January 3rd, 2025. For this felony of the 1st degree, the court will sentence you to that firearm specification of 3 years prior to and consecutive to an 8-year sentence. On the minimum side, the indefinite period of time, 50% of 8 years is 12 years. So on the base charge of aggravated robbery, you will have an 8 to 12-year sentence, but that is consecutive to the 3-year firearm specification. And it will be consecutive to the aggravated murder and the aggravated murder on the first 2 counts, 698 and 632. On count 13, before I move to count 13, that aggravated robbery felony of the 1st degree, the adult parole authority has a mandatory minimum of 2 years up to a maximum of 5 years of supervision on that count. On count 13, grand theft, when the property is a firearm, the court is finding that that is an allied offense of similar import. The court is sentencing you on the 3-year firearm specification pursuant to the Ohio Supreme Court's case of State v. Bolar, 2022, Ohio 4370. Firearm specification, even though the underlying offense is an allied offense, is to be run consecutively. I'm finding that by an operation of law, but I am also finding it within my discretion pursuant to the Ohio Revised Code statutes referred to by both defense and the state during sentencing. As to count 14, possession of a fentanyl-related compound, felony of the 2nd degree, there the court will give you a sentence of 8 years on that matter. That will be run concurrently to all other cases and all the other counts. I'm not giving the indefinite sentence as I have done so already on the aggravated robbery charge on this case number 700674. And then count 15, your PRC, post-release control, for a felony of the 2nd degree is a mandatory minimum of 18 months up to a maximum of 3 years on that. For the having weapon while under disability, the court tried to the court. Count 15, this was original count 12 on case number 698632. You'll receive a 36-month sentence, and that will be run concurrently. You will receive court costs on these two case numbers. The court will not issue a fine on these matters, finding you to be indigent. As to the ERMPT again.
I'm sorry, what did you say?
ERMPT, earned reduction of minimum prison time. Again, it does not apply to the life sentences, but it will apply to the other non-life indefinite prison terms, as well as to the other offense, RSP and fentanyl and weapon under disability. And as to your PRC, if you violate any post-release control rule or condition, you may be subjected to a more restrictive rule or condition, a longer duration under supervision, or you could be sent back to prison even though you have done all the time to which you have been sentenced. You could get up to 9 months in prison for each rule violation. The total, however, for all rule violations cannot be any more than 1/2 of the prison sentence that you receive unless the rule violation is for the commission of a new felony, in which case you could receive a prison term of the greater of 1 year or the time remaining on post-release control, in addition to any time that you receive for the new felony. The post-release control prison term must be served consecutively to any prison term that you receive for the new felony. As to the consecutive sentences, which the court has reviewed the statutes before imposing the sentence, the court finds under 2929.14 C4A and C4B and C4C the following. The court imposes prison terms consecutively, finding that the consecutive nature is necessary to protect the public from the future crime or to punish the defendant, that the consecutive sentences are not disproportionate to the seriousness of the defendant's conduct and to the danger defendant poses to the public, and that the defendant committed one or more of the multiple offenses while the defendant was awaiting trial or sentencing, or was under a community control, or was under post-release control for a prior offense, as we've discussed. And then under that same statute, C4B, the court imposes prison terms consecutively, finding that consecutive service is necessary to protect the public from future crime or to punish the defendant, and that the consecutive sentences are not disproportionate to the seriousness of the defendant's conduct and to the danger defendant poses to the public, and that at least 2 of the multiple offenses were committed in this case as part of one or more courses of conduct, and the harm caused by said multiple offenses was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of the defendant's conduct. And under C4C, the court imposes prison terms consecutively, finding that consecutive service is necessary to protect the public from future crime or to punish the defendant, that the consecutive sentences are not disproportionate to the seriousness of the defendant's conduct and to the danger the defendant poses to the public, and that the defendant's history of criminal conduct demonstrates that the consecutive sentences are necessary to protect the public from future crime by the defendant. Also, the calculation of the court for both cases is that you are to receive 286 days of credit for time served from January 14th of 2025 through today's date of October 27th of 2025. And then perhaps lastly, your right to appeal. You have a right to appeal. If you're unable to pay the cost of an appeal, you have the right to appeal without a payment. If you're unable to obtain counsel for an appeal, counsel will be appointed without cost. If you're unable to pay the costs of documents necessary to an appeal, such documents will be provided without cost, and you have a right to have a notice of appeal timely filed on your behalf. Ms. Carcutt, is there anything further for the state? Does the court need to do anything more?
The aggravated murder registration for violent offender.
Sir, you have certain duties as a violent offender, ORC 2903.41. The court will follow, will complete the top of this for you. Do you know your Social Security number, sir? You can tell it to your attorney and your attorney can put that in for you, so it's not necessary to have on the record. You do? If not, you can fill that in afterwards. The county of conviction is Cuyahoga County. The 2 case numbers will be placed to the next. The convictions for the ORC numbers for the aggravated murders will be placed in there by the court. Your name, last, first, will also be put in. Your current address before you were incarcerated will be put in as well. Number 1, you have been convicted of or pleaded guilty to a qualifying violent offender offense as defined in ORC 2903.41. Number 2, you are required to enroll in person with the sheriff of the county in which you establish residency within 10 days of coming into that county or of occupying or dwelling for more than 3 days in the county. Number 3, you are required to provide the sheriff certain information, including your social security number, full name, and alias you use. B, your residence address. C, information regarding the offense of which you were convicted or pleaded guilty. D, a description of any scars, tattoos, or other distinguishing marks on your person. E, the name and address of any place where you are employed or attend school. F, any driver's license number or commercial driver's license number or state identification card number issued to you. G, the license plate number of each vehicle owned or operated by you or registered in your name. The vehicle identification number and a description of the vehicle must also be provided to the sheriff. 4, you are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of enrollment. 5, after the date of initial enrollment, you are required to re-enroll annually. You must update and or amend any of the information described above that has changed and provided any additional information requested at the sheriff's office within 10 days of the anniversary of the calendar date on which you initially enrolled. 6, if you change your residence address, you shall provide written notice of that change to the sheriff with whom you most recently enrolled and to the sheriff in the county in which you intend to reside. You are required to comply with all the above described requirements for a period of 10 years unless your sentencing court determines otherwise. 7, since your expected residence address is located in Cuyahoga County, you shall enroll in person no later than 10 days after release or sentencing if you were not subject to incarceration with that county sheriff's office located at 1200 Ontario Street, Cleveland, Ohio, Justice Center for now. 8, failure to enroll or failure to verify residence at the specified times will result in criminal prosecution. 9 is your acknowledgement. I acknowledge that the above requirements have been explained to me. I understand the requirements and that I must abide by all the provisions of the Ohio Revised Code, Chapter Section 2903.41 through 2903.44, and you would sign there. Have you understood everything I've said so far, sir?
Yes, sir.
All right. So I will allow Ms. Tipping and Mr. Schleichen to take your signature in the other room and then provide that to the court. And then 10, I will sign off on that I certify that I specifically informed you of your duties set forth above, and they indicated to me an understanding of those duties. And so I'll sign that after your attorneys bring me that. Anything else, Ms. Carpenter?
No, Your Honor.
All right, and thank you for that. Appreciate that. Mr. Schleichen?
Judge, would you assign him appellate counsel? He is indigent, remains indigent.
I will assign it, and I did read him his rights to appeal. I will do so. All right. Thank you very much. Anything further besides that? No?
Judge, can I just have a clarification? It might be my inability to understand. Counts 1 and 2 are consecutive?
That's correct.
Thank you.
And count 8, and count 12 as well, right, Your Honor?
Yes, I was just answering his question specifically, yes.
Well, I want to
Okay.
make sure it was clear for counsel as well.
The consecutive counts are counts 1 and 2, and the aggravated robbery count as well, which is count 12, I believe.
Thank you.
With the consecutive nature of all the firearm specifications, there being 4, the journal entry will specifically explain again that I found those to be consecutive by operation of law, but also discretionarily by the court. All right. Thank you.
Okay, with the court.
All right, those forms signed, Judge?
One side, then the other, please, guys. Thank you, deputies. Do you want these all? Do you know? Is this, do you know, is it the 2 or is it the other? Is that yours? Okay. All right. Thank you for being here. This you?
Yes, that's me. Thank you.
All right.
I got a gun.